Welcome to Decision Vision, a podcast series focusing on critical business decisions. Brought to you by Brady Ware & Company. Brady Ware is a regional, full-service accounting and advisory firm that helps businesses and entrepreneurs make visions a reality.
Welcome to Decision Vision, a podcast giving you, the listener, clear vision to make great decisions. In each episode, we discuss the process of decision-making on a different topic from the business owner's or executive's perspective. We aren't necessarily telling you what to do, but we can put you in a position to make an informed decision on your own and understand when you might need help along the way. My name is Mike Blake, and I'm your host for today's program. I'm a director at Brady Ware & Company, a full-service accounting firm based in Dayton, Ohio, with offices in Dayton, Columbus, Ohio, Richmond, Indiana, and Alpharetta, Georgia. Brady Ware is sponsoring this podcast, which is being recorded in Atlanta per social distancing protocols. If you like this podcast, please subscribe on your favorite podcast aggregator, and please consider leaving a review of the podcast as well. So the topic we're going to discuss today is, should I pursue a workout for my business? And by workout, I don't mean go to the gym and make your business buff somehow. I'm not sure how that would go, but there's probably a business coach out there that adopts that kind of branding, I suppose. But rather, frankly, kind of the other side. And, a workout is, in case you don't know, a workout is a process where you reach a point where you can't pay all of your bills in full on time. And it's sort of, and we'll get into the proper definition in a minute with our guest, who's the expert. But it's sort of this in between land, if you will, of financial health and solvency on the one end of the spectrum, and at the other end of the spectrum, some sort of reorganization or liquidation. And unfortunately, excuse me, I suspect that this is a topic that is particularly appropriate and timely and relevant. We think, as we record this in mid-June, that we think we're coming to something that approximates a recovery. But the fact of the matter is that, life is going to go on, but it's not necessarily going to go on for everybody in terms of businesses. And it's not going to go on for everybody, at least as the way that they had hoped to or wanted to. And a workout is a process where you try to kind of work things out. I think that's probably the best way to describe it. And, I've assisted clients in a tangential way. I don't want to position myself as an expert here on this because I am not. But I have ridden shotgun sidecar with some clients on a workout process, and it's tough. And it's tough because nobody likes it when you tell them that you can't pay them. That's just, nobody's going to welcome that with open arms necessarily. And some of those conversations can be very unpleasant, indeed. And, few people, I think, frankly, like telling somebody that I can't meet my commitment to you, especially a financial commitment. And it really tests, frankly, it's going to test your own commitment to your own business in a lot of ways. But there are right ways to do a workout. There's a wrong way to do a workout. And there may be a point where a workout is not appropriate, right? You may be thinking you have to enter a workout too soon. And there are ways you can avoid that. And there are, on the other end of the spectrum, a workout is just going to be too little too late. And you need to look at things that are options that are more drastic. And so helping us with this as our guest today is my dear friend, Tom Rosseland, who is with a law firm called Bodker, Ramsey, Andrews, Winograd, and Wildstein. I always feel badly for anybody whose name comes after the first two because nobody ever says the final names after the first two. For example, my firm is Brady Ware and Schoenfeld. Nobody ever says Brady Ware and Schoenfeld, and I'm sure Schoenfeld is or was a very nice person, very capable, but for whatever reason, they sort of got screwed. So to mishears Andrews, Winograd, and Wildstein, I'm sorry about that, but you'll have to work it out with your own partners on that. But Tom represents domestic and international clients in a variety of industries and practices in the international, corporate, employment, and business litigation areas. Tom has worked with and successfully handled a wide array of complex legal matters for individual and corporate clients. He extensively works with chief financial officers for many businesses, and he also supports the C-level community, both professionally and personally, as a mentor and as a networking resource. I'm happy to personally attest to that. Tom is also the host and moderator of the International Business Radio program on probusinesschannel.com. I did not know that. He's been holding out on me, and serves as chair of the international section of the Atlanta Bar Association. Early in his career, Tom has served as in-house counsel for ExxonMobil. Born as a first-generation American to a Swedish mother and Norwegian father, Tom now serves as the honorary consuls for both the Kingdom of Sweden and Kingdom of Norway in Georgia. Tom, thank you so much for coming onto the program. I'm tempted to try to do this in Swedish, but I'm not going to, so I'm just going to say welcome and thank you so much.
Well, thank you so much, Mike, for having me on the program. Excited to talk about the subject matters that are probably going to be of consequence in the months ahead. And so feel free to fire away with what you think might be relevant to our audience.
So here's a question I've always wanted to ask you, and I never have. It has nothing to do with the topic whatsoever. Is there ever a conflict of being the honorary consul for both Sweden and Norway? Do they ever get mad? They think you're pro-Norway, because those two countries have a long history of smash and grab violence.
You're right about the history, but thankfully Norway gets to award the Peace Prize every year in Oslo, and there is actually a very cordial relationship now between the two governments. So Norway got its independence in 1905, and I think that the good feelings that have come out of that are the current vibe. So, in fact, the opportunity to come be consul for Norway came after I was already appointed by Sweden, and the offer was related by my contact at the embassy, the Swedish embassy in Washington. She said, "Would you be interested in being a candidate?" Because the Norwegians had reached out to her. And I asked the same question you asked, which wouldn't that be a conflict? And basically, she indicated that there was they have such overlapping interests and do so many things together that, in fact, that would not be a problem whatsoever. And in fact, she had already gotten approval from the Ministry of Foreign Affairs in Sweden and Stockholm to, if I could work it out with the Norwegians, go for it. So that good question, but no problems these days.
All right. So let's clean up the mess I've already made describing what a workout is. So what is a workout? Was I even close in my definition at the introduction?
No, it's very good. You nailed it, I think. There's a whole range of issues that come out with workouts. And a workout can be, essentially, it's an alternative to bankruptcy. And in many ways, the idea is that you get to an endpoint that is acceptable to both parties. But it's a process. And that's the point I want to emphasize, that it's so important that you come to it with eyes wide open. And to your point, Mike, that there are going to be uncomfortable conversations, because no one likes to come back to a creditor or a counterparty that you owe money to and start talking about why you can't pay them in full or you can't pay them on time. But I think that the most important thing you can do earlier in the process is to be mindful of the moving parts, being aware of what are the administrative requirements of that agreement or the contract, getting things mapped out, and being proactive and being candid. I think the most important thing people come to the table with is their credibility. And the way to maintain that is to go ahead and be forthright and to be entirely candid about what is going on. There are other ways that this can be played, where if a workout comes into play and there's already distress in the relationship and there's already some level of, you can call it recrimination or just a dispute that's in the offing, there are other tactics that we can use to come to the same endpoint. It's just, it depends on where you are in the cycle. And I think that the earlier you can identify the issue and call the question, the better off you are in many, many regards. I don't know if you want to just elaborate.
So what's the difference? I mean, I think everybody struggles to pay bills at some point. What is that tipping point where you're not just struggling to pay bills, but you need to sort of take more dramatic action and start making kind of really hard and uncomfortable choices? What does that tipping point of that inflection point look like?
I think just based on your own historical experience, we can talk about it from the perspective of a business owner and operator, or somebody who has, a high net worth individual who has a lot of obligations that are guarantee obligations. It's basically the same conversation or the same approach. But I think the tipping point, Mike, would be when you are no longer able to carry on as you are used to doing and expecting to do. So if you are now in a different place that is making you stay up at night and it's different than what it has felt like in the past, your gut is telling you something that you need to be listening to. And I think it's at that point where you need to go ahead, and it may even be before your bills are at that point of being out of sorts or being out of order or not being paid. I think that certainly will, that will call the question when you're not paying or being able to pay. But if you can think ahead and put wishful thinking aside and just say where things currently are for me and my business, I've not been there before, and I'm looking at a wall of debt or obligations that are coming due. I need to figure out what my plan B is. That's the time where you've hit the tipping point. I think that's the easiest answer or most straightforward answer.
Now, is there I'm thinking, is there a difference between, look, I'm probably going to pay bills a little bit late, but they're still going to get their money. Versus, I guess what you're describing is that you're looking ahead and you're just seeing an avalanche. And it's not just that I'm going to be a few days late paying some bills, but, probably many bills are going to wind up going into delinquency, I guess, if I don't get ahead of that. Is that a reasonable way to think about the decision?
It's a reasonable way to approach the decision. And also it touches upon the tipping point, Mike, whereas if you've got a handful of obligations, it might be rent obligations or things like that, where with the current environment that we're having, a lot of landlords are expressing some leniency or willingness to defer payments. That's one thing. But when you actually have a stream of payment obligations to various of your vendors and your creditors that are coming due that are systemically, from your perspective, going to be a problem to manage, that's where I think you have to have that bigger conversation. So there's just a one-off, there may be a glitch where you've had a customer file bankruptcy on you or something where, your cash flow is being affected by, due to no fault of your own, but it is something you expect to surmount in the next few months. That's one set of issues and opportunities and conversations. It's another one where you're looking at just a broader picture that may be driven by economic factors beyond your control.
And let's drill down on that because I think there's potentially a really important point there. Are all workouts created equal in terms of the conversation? What I mean by that is are creditors going to react differently if they perceive that the reason for the workout is something that is clearly an act of God, say a pandemic? We know that would never happen, right? Or murder hornets, versus simply you didn't manage your business very well. Like it's clear that you just sort of screwed up or you were cavalier, right? Do creditors want to hear the reason for the workout, or do they immediately sort of generally just say, well, now my money is at stake. I really don't care about the answer. And now we kind of move forward.
That's an excellent point. I do think that they care to know how you got there, to the extent that helps them to understand your perspective about how you expect to get out. So I think that they are interested in learning about the entrance point of, to your problems and how long that's been going on. Nobody wants to just have their shoulder cried upon as the basis for a negotiation or a discussion. I think, though, you do get sympathies with creditors where if you are, if you've had a good payment history or a good working relationship, and that really is the driver of this conversation, right? If you have a, quote, relationship with that creditor and something comes up that's untoward and unexpected, you will get sympathy, especially if you've been doing all the right things and then something, comes your way. But if it is, if you were basically sideswiped by an economic event, such as what we're dealing with right now, that's one thing. they understand we're all, sharing some version of those pain points. It's a question then of what are you going to articulate as an approach to get out of that ditch, so to speak, and what can you help them to map out with you? So how can you get them to support the vision and then move forward from there? If that is something that you have that opportunity to create a relationship. It's really hard to create a relationship with a creditor that you've had antagonisms with. If there's been operational issues that have resulted in a lot of friction in the past, that goodwill factor is not really there, right? So in that situation, very often these kinds of things, we joke about agreements, right? The best agreements are the ones that are written up and that you never have to look at. And that means You've got a great relationship. But then if something goes south, everyone starts pulling out the papers and looking at the finer points in the documentation. And more attention will be focused on the finer points in the documentation, the more you're sideways in terms of that relationship. So I think if you've got a good relationship, very often creditors are willing to sort of look aside or not really focus on the language of the agreements. If you don't have that goodwill, you're going to be starting to look at a bunch of paper and and legal terms that will come into the conversation.
And I'm glad you brought that up too, because there's this concept out there, I believe, of a technical default, which I understand means that you're still paying your bills, but maybe you're required to have some sort of interest coverage ratio or certain financial metrics you're supposed to meet. So you're still meeting your cash payment obligation, but on the other hand, you're not maintaining a level of financially measured health as maybe your loan covenant or other covenants dictate, right? Is there a difference there too?
Yeah, absolutely, Mike. I mean, there is those situations where you are maybe servicing the obligation, but there are other events of technical default. There may be covenants that you're not complying with. It could be anything from insurance coverages to other duties that come into the relationship. And that's when you start getting into, the creditor, your counterparty saying, we reserve all rights. So we are talking to you, but we reserve all our rights, and technically this is to notify you. So if a creditor is wanting to keep its options open, and still work with you, they will send out a notice saying that under the provisions of that agreement, you are technically in default, and that creditor reserves rights to pursue relief for that default. But at this point, any conversations will not be a waiver of those rights. Does that make any sense?
Yep, it does. So, in that vein, I'd like to get into another, I think, potentially very important technical definition, which is the difference between a workout and a Chapter 11 restructuring. We know Chapter 7 is game over, sell everything off, and let people figure out how much they're going to get out of that. But Chapter 11 sounds to me like a workout. It sounds to me like it has a number of things in common with a workout. Are they the same thing, or are there important distinctions between a workout and a Chapter 11 reorganization?
Yes, that's a great question. The bankruptcy process in and of itself, and I cut my teeth when I started practicing law, dealing with credit issues in bankruptcy for a number of years, and I'm very familiar with that area. So the bankruptcy provisions or the code, Chapter 11, is basically, as you said, a reorganization for a business. The problems with the Chapter 11 are the costs. They're very expensive. There is the administrative oversight by the court. They also have the bankruptcy trustee. It's either a court-appointed trustee or the U.S. trustee's office that they directly work for the government. You have a lot of reporting requirements in a bankruptcy. You are court supervised. So any action that you would propose to do in a bankruptcy is going to be overseen by somebody, whether it's by the judge or by a trustee, but there is going to be a heavy level of reporting and accountability. And a creditor also may not necessarily appreciate having you in bankruptcy, because there is this thing called the automatic stay, which basically prevents a creditor from unilaterally taking action to collect on a debt without the blessings or permission of the court. So the outcomes of a Chapter 11 could very, very much be the same, perhaps, as a workout. So, for instance, in a Chapter 11, you can actually have a company that restructures itself and recapitalizes itself and moves on. That's what we would call a successful Chapter 11. You have also things called a liquidating Chapter 11, which is that bankruptcy essentially is a sale of assets that's court supervised, but the door's open, the lights are still on, so you don't have a garage sale, you don't have a fire sale, but you basically end up having creditors getting assets of the company for distribution, or a purchaser would sell those purchaser would buy those assets, and creditors would get a portion of those proceeds of the sale. A workout is out of court. It's meant to be a non-judicial proceeding. It's meant to be consensual. There is no oversight process. There are things such as what they call an assignment for benefit of creditors, which has some level of supervision or reporting to a court. But typically, a workout is meant to be an independent thing that you are doing yourself, with the creditors involved, without other parties' supervision other than the relationships you have with the creditors or whatever deal you can structure under the circumstances.
So you bring up an interesting distinction, which I think, to mind, I think is one of the most important things is that when you declare bankruptcy, you are limiting the choices of your creditors, and at least temporarily, right? Their ability to act and influence. And therefore, it seems like that's a much more aggressive posture to take than initiating a workout initially, right? In a way, I guess there's sort of a graduated series of events potentially where I could certainly see a scenario under which you might start with a workout and then go into bankruptcy if the workout is not effective. But on the other hand, if you declare bankruptcy and then you say, oh, never mind, let's go back to a workout scenario, that's probably a lot harder to do, since a bankruptcy basically slams a door in your creditor's face.
Yeah,
is that fair?
That's an excellent point, Mike, which is, filing a bankruptcy is sort of very often is the last option that you want to pursue. And so for me, when I advise clients in terms of their range of options, typically the end of the line is a bankruptcy. There are cases, though, where it's very clear based on the nature of the obligations and how much debt there is and how big the business is and what its prospects are, that you might come in knowing you're a big enough company with enough assets and enough of a runway to actually have a successful outcome. And you can get what they call debtor in possession financing. If you have your financing sources lined up, you know what the problems are. You're trying to go into sort of a one-off event that occurred. You have a pathway and a game plan. You can file a Chapter 11 and actually get a good outcome if you think far enough ahead. They even have bankruptcies that are called prepackaged Chapter 11s, which is you've already talked with your creditors. You've already worked things out with them. And, there are things you can do in a bankruptcy that you can't do anywhere else. Like in a bankruptcy sales, you can sell certain assets with the permission of the court, what they call free and clear liens and encumbrances. So there are certain things where, if a creditor is wanting to accomplish even something in the nature of a workout, they might just say, we need you to do this, that, or the other, which may include a bankruptcy filing and a sale of those assets free and clear, just to clean title up to those. But to your point, Mike, very often, typically, for me, when I go ahead and make a recommendation to a client about a bankruptcy, that is the last straw, because you typically have very heavy-handed supervision, as we've talked about, and there are tremendous amounts of administrative costs with professional fees and reporting requirements. You have, a monthly budget, you have monthly expenses, and all that takes a lot of time and is a distraction to the process. So going back to the idea of a workout, I think, if you have the runway and the wherewithal to sit down and think about your strategy is, and you can work it out with those creditors, that creditor or those creditors outside of bankruptcy, it by far is preferable. But not always. There are times when it's apparent, evident, self-evident that you need to do something more than a workout. I don't know if that answers the question.
No, it does. So let's fast forward a little bit, or advance the ball a little bit. I'm a client. I've decided that I want to, or I need to, place myself or start having workout conversations. I walk into your office, say, Tom, I'm in financial trouble. I don't think it rises to the level of bankruptcy yet, but I need to frankly work things out with my creditors. What are the immediate things I need to put on my to-do list? What are you telling me to do as my advisor?
Yeah, thanks for that. And that's exactly right. When people come in very often, and I'll have to share this, that I've seen it again and again, very often by the time people come my way, they are already what we call in the bunker. They already almost have a siege mentality. They are beaten up or downtrodden, and they've gone so far down negative alleyways with their creditors that very often they come to me, unfortunately, later in the game than they should. But if I have the opportunity to help somebody, it's not a blank slate, but at least it's certainly where there's an opportunity to make a difference. I would ask them to come in and before they even come in, give me a 1 to 2 page summary, chronological summary of how they got to where they are, and keep it short and keep it succinct and concise, and then also what's their thought process about how they would propose to move on. What would be the thing that they would need to accomplish to turn things around? Now, if they realize that it's too late in the game and their business is just, so to speak, done for, if there is no obvious opportunity based on market conditions or where they are, then we can look at other things that would at least buy time, would at least perhaps defer the obligation. So in that situation, I can work with them and then be more focused on what, if we can't get a resolution in terms of getting you right-sized, then what we can at least talk about is mitigating your exposure. What can we do to mitigate your risks and your exposure with your creditors in a way that gives you a meaningful outcome? And then that becomes a conversation focused on enlightened self-interest with your creditors. How can you show them to their satisfaction that they have an incentive or a reason to play ball, and that they will do better by working with you rather than the alternatives? And one of those alternatives I've seen is, worst case, you come to a creditor. And again, it depends how far down the road this thing has gone. But if it's pretty far off the rails already, a creditor might say, well, I'm not really liking what you're telling me, or I'm not buying it. And that comes down to them wanting to see your financial information. So they will likely ask for some detailed financial information. And then it's up to you whether you want to sort of tip your hand, because they're going to look for what assets you've got. And if there's a personal guarantee involved, there's all kinds of ways to skin this thing and to consider it. But, they may want more information that you're comfortable in sharing. And it may be where you actually have access to resources that are not really your family. It's not your money in your bank account, but you have, a father-in-law or a mother-in-law or some relative who could actually help, but they're not really on the line for any of this. So there are times where, it's appropriate to pour mouth yourself, even though you might be in a situation where, if there's an opportunity to be had, you might be able to tap those additional lines of credit, not informal lines of credit, to see if you can, turn things around with the creditor. But I think, that creditor is going to be very focused on what you got, and they may want to have, a lot more access to information than you're willing to share under the circumstances.
So it sounds like then one of the key items on that to-do list is have your financial documentation in order, right? And that may include some sort of forecast or projections as well, right? Because at some point they want to know what your plan to pay them back is. Do you think creditors care if this is a blatantly self-serving question, but it needs to be asked anyway. In your experience, do creditors care if you're working with, say, a CPA to put that information together?
They would.
Does that help?
I think in certain situations, in terms of, it depends on whether you're actually having a good faith negotiation with the creditor or you're doing some version of blind man's bluff. I think that in many situations, working with an accounting firm and getting a financial professional involved to look at the numbers for the business is very helpful to the process, especially if the accounting firm or the financial professional can translate things in a way that's meaningful to a creditor that they would want to focus on. So I think there are absolutely appropriate times to actually have professionals help with that process. And to me, I've done this long enough to appreciate that when people come in, and they want to schedule a meeting with me, I make it as a matter of course now a request that they actually, before the meeting, email me confidentially that short summary of what's going on, because if they can't bother to even sit down and put pencil to paper and help me with that thought process before they come into the office, they're not really invested in their own success. And I need somebody who's actually going to show that they have skin in the game. And going back to your point, Mike, I think having professionals involved is great. The one thing that would come into play is if you're coming to a creditor and saying, I'm broke, they might just want to know, well, how did you get a really good firm, such as Brady Ware to do those things? But that's that time, that place. But I think there's absolutely a role for financial professionals in this process.
And that leads into another question, which is, in that advisor conversation, there's actually a broader issue, which is if I'm the company owner or I'm the executive that's sort of somehow in charge of this for my company, it's got to be really tempting to see if I can find somebody else and just sort of have them take care of it, right? I mean, we'll get to this in a second, but the conversations are not pleasant. They're humbling. They're humiliating. They may get heated, frankly. And so the temptation would be to, hand it off to a subordinate. The temptation would be to, okay, Tom, I just need to work out. Here are my creditors' phone numbers and emails. Here are my financial documents. Here's my CPA's phone number. Go make it happen, and then come back to me when you have the plan set up. Sounds great. Is that a realistic process?
Wow, that's a fabulous question / observation. And they're all different reasons for doing it different ways. I'll say for the most part, offshoring and offloading that process to other folks is not necessarily, there are certain times where it is a good idea. But I think in general, you need to have the stakeholders, the chief executive, or certainly the C-level people in the business, at least involved in some fashion. And to offload it raises its own challenges. I will say that, for instance, what I typically recommend to a business owner or manager is that, let's not lawyer it up. Let's go ahead and let me help you with the conversation. So let me give you some guideposts and some discussion points. Let's go ahead and see what we can accomplish. And whether it's the owner or the manager or some senior person who has a relationship with that creditor actually starts trying to make things happen. Because for them to lawyer it up on the front end, I'm going to be stuck dealing with the creditor's attorney, because typically a creditor is going to get their attorney involved once I'm reaching out on behalf of my client to the business, the creditor. They're going to say, okay, fine, you got a lawyer, I'm going to get a lawyer. And then the ethical rules are that the lawyers can't talk directly to the opposing party. They actually have to go through the opposing party's attorney. So it becomes another layer of communications that may be appropriate under the circumstances, but I typically am not the one, unless my client, who owes the money, is aggrieved. They were clearly taken advantage of, and there is a reason to raise my hand as an attorney and say, hey, we've got a problem here, Houston. I'm going to go and try and help the client, work that conversation through, and then I will eventually appear on the scene if necessary. But that's the typical way I'd recommend it. Now, getting third party, financial professionals, again, it depends on how big a mess it is, and if in fact the manager / owner of the business that's in distress has lost all credibility, with that creditor, then it certainly makes sense to bring in financial professionals who can help with that conversation, or even the attorneys, because nobody else is going to be listening. That party owes the obligation is persona non grata. Then we have to find other ways to have that conversation. So I don't know if that answers the question.
It does. So now we've been talking a lot about. We've been using examples that heavily involve banks, because that's sort of the classical workout posture. But a workout may involve other creditors as well, right? It's not just for breakfast anymore, not necessarily just for banks, right?
Absolutely. No, there are, you name it. There are, so-called private banks. There are a lot of investors, who, even though they may not have documented the relationship as An equity investment, it's a loan, but there is a lot of money out there that's non-bank money that clearly plays into this process. And everyone has different motivations. So when we talk about workouts and restructurings, that's not related to banks. Very often, it's actually quite the opposite. But
what about landlords?
Well, so yeah, landlords are almost any creditor, including your landlord, is somebody you could work with if done with a proper approach and come to a resolution. So absolutely, the universe of creditors includes everything from landlords to trade creditors to vendors to you name it, that are all non-bank. And very often it's those things, those trade creditors and vendors that come in, crash land on your deck that are insisting on getting paid. And, that becomes your pressure point. So very, very often the banking process is the last thing that comes into play. And that may be triggered because then you are in violation of covenants, or you are not able to pay a certain loan with that bank based on these other creditor issues. So they may come into the mix, but that's not always, where it starts. It goes any number of directions.
So let me I want to ask this then. Once you kind of start these conversations, how do you manage? Can you manage emotions in the scenario? You described, with a lot of depth, and I think this is important, is, most people, frankly, if they're not sociopathic, when they walk in, they feel badly that they're defaulting on obligations, right? And they feel like they are a failure. Their business is failing to some extent. And they know you're going into a situation where the outcome of the phone call is that you're going to be disappointing somebody, right? How do you manage the emotions of that conversation so that it doesn't spiral out of control and the emotions don't dominate the conversation as opposed to a more constructive problem-solving posture?
That is, again, just spot on. I for me, having done this long enough, my role is not only to be an advocate, but to also actually be an advisor who manages the process in a positive way and a proactive way, and also trying to take the emotion out of it. So when I communicate with my clients about how do we respond to a creditor, how do we go ahead and have a communication with a creditor, I always tell them to be aware, that really your audience, think about this. If it goes south and it becomes a litigation matter, then very often the communications, the correspondence, and the documents that are being exchanged, right, will become an exhibit, in a court-related matter. And so for me, when I'm looking at the audience, is not just the creditor, but who may end up being, asked to second guess who did the right thing or the wrong thing in the moment, with regard to the debt at issue and what the process would look like from an equitable perspective or a legal perspective. So that allows me to actually help the client think in a different way. They may want to shout at the moon, howl at the moon, all those things, vent, scream in a quiet place and all those things. But to get them to a place where they're in a better situation or a clearer posture, my goal is to sort of take the emotion out of it. And it requires a lot of empathy on my part. So I think when clients understand that I am in their shoes and I'm actually thinking for them and very much concerned about it, and that I'm very tactically aware of what's going on in the moment. If I know where the traps are, the movie traps, and where they would likely get into some significant exposure, and they know I'm taking that on, they can almost transfer some of that stress, and they still have the financial part of it, but they understand that I'm thinking, that process through for them, and I'm their advocate, then they become a lot more clear-headed that they can get out of the bunker and start helping me to envision the best pathway to have either an outcome that's acceptable or at least a conversation or a pathway that is more productive than it would otherwise be.
So, we pick up the phone, you and I come to your office, we have the speakerphone on, the door closed, we start making these phone calls that we didn't want to have, but we got to make them. at the end of the day, a workout seems to me what you're really doing is you're going on a campaign to ask people for something financial who have no obligation to give it to you, right? What are the most common concessions you see, or the most common asks you see on behalf of creditors in exchange for agreeing to a workout program or a workout concession, whatever the proper term of art is? What should I expect to have to give up in order to get what I want from my creditors?
So I think the typical creditor, right, doesn't want to leave any money on the table. They need to be convinced that it's in their own self-interest to deal. So I've had situations where I've reached out to creditors, bank and non-bank creditors, and have said that my client is in financial straits. Here's where we are, how we got there. Here's what we're asking you to help us with. And then very often, the things, Mike, that the creditor will be asking for, would be asking for, financial statements. They may want a sworn financial statement where basically you are under oath, saying this is a true and correct summary of your financial condition. They may want to be asking, if they're really, really focused on things, they may want to know about, what your assets are and where, if any, transfers have occurred. If a creditor is really, really, into it full tilt, they're going to go and do their own search of real estate records, just to see if there's been any transfers, interfamily transfers of real or commercial property, just to see, if you're poor mouthing yourself. I think the problem is it depends on how much the creditor already thinks it knows you. So the creditor thinks that you are a high net worth individual or that your company is doing very, very well. They're going to basically have a disconnect saying, how did all this money go away? Why are we here? What can you share with me that actually gives me, the creditor, comfort to know you're not playing a game with me? Because that happens a lot, unfortunately. I mean, I will never willingly or knowingly be a party to any of those things, but it happens. So I think the creditor has to actually be assured that you are actually speaking a truth that they can appreciate. And I think what a creditor, would want to know is either you got a legitimate story to tell or you don't. And I think, that's where it comes to, very often I will say to a creditor, if we can't work this out, my client, may have to file bankruptcy. And you will get less in a bankruptcy versus what we're trying to do under the circumstances. And I tell my clients that I represent in that situation, be aware, be prepared for the possibility that creditor might say, well, you know what, I'll take my chances, file your bankruptcy, because then I know I'll get a full disclosure. Again, that goes back to the whole idea in bankruptcy. You do have a whole variety of tools a creditor has to get discovery as a matter of course, that would require less work or more work if this were a non-bankruptcy situation. There's a litigation matter, for instance, right? And there's a lawsuit. Then the creditor has to actually, do what they call discovery. You have to actually seek a production of documents and financial information. And in bankruptcy, it's almost as a matter of course that you, as the debtor in bankruptcy, have to disclose a variety of information without that much effort on the part of a creditor to actually have that required of you to stay in the bankruptcy proceeding. I don't know if that answers the question.
Well, it does, especially on the informational side. Now, I want to approach this on the financial side too. In my experience, if I ask for a workout, a creditor is going to ask for something in return to compensate me for forgoing something financially, and frankly, for what you just described, right? By initiating a workout, I have now just inflicted a series of expenses upon my creditor that they would rather have not spent, right? Whether it's legal fees, accounting fees, investigation, all that sort of thing, right? So in addition to the informational burden, can I expect to be asked to make concessions in terms of could be governance and oversight, maybe a board seat? Could it be stricter lending covenants going forward? Could it be an increase in an interest rate? Could it be some sort of equity position such as warrants, things? All of the above, none of the above? What can that look like on the financial side?
Yeah, and the range of options could be, to your point, all the above or any of the above in terms of what a creditor could ask for. Because what you're basically asking a creditor to do is go outside the terms of the document, right? The contract provides for this, that, and the other. You know what that script looks like. You know what the creditor can do under the circumstances. You're trying to convince the creditor that it's in their best interest, right, to come to a different outcome than what they would otherwise have expected. And to show them that that is actually the best pathway for that creditor under the circumstances. So I think it could very well be where a creditor would ask for more oversight, more financial reporting, a change in the covenants where there may be a trigger point. They may defer the debt, in renegotiation of the debt. And so very often what they'll do is they'll defer, extend, renegotiate the debt. But their new version of reality is going to be a stricter one, which is you crossed, we moved that whatever tripwire and we moved it down, a few yards or a field down the way. But next time you hit it, we're going to come, at you for more. They might ask, for instance, for not only personal guarantees, they might ask for collateral. They might say, what you got in terms of real estate, what you got in terms of bank accounts. So they may want to have a position where they're not going to be behind, that they will actually be in a better place and better prepared to collect on that debt if you still can't service it. So that's one of those situations where it's very important to talk to your attorney to confirm that that you as the person owing that debt are not digging a hole that is a worse outcome for you down the road than what you're currently dealing with as the waterfront of issues, if that makes sense.
So, in your experience, I think kind of one of the big kind of very high level questions is whether whether it's worth entering a workout scenario at all from a perspective of is this one of these things where once you enter a workout, you're very unlikely to ever come out, or is it possible that more companies than maybe the average person thinks, if they do get creditors that are willing to play and be constructive in the conversation, do a lot of companies actually successfully exit the workout process and are able to put that behind them and ultimately thrive?
That is, as in everything else, entirely dependent on the nature of the business, the nature of whatever dysfunction or the interruption that occurred that caused these problems to take place. What's the vision looking like? It's a leadership question. I think a creditor wants to know, okay, this is sort of like, it's the same thing where it's an irony, but in bankruptcies, Chapter 11 bankruptcies, the big ones, very often the management team that's putting the company into bankruptcy seeks to get compensation or bonuses, retention bonuses, just to stay on board and keep the ship, keep the lights on and keep the ship running. And very often creditors shake their heads like, let me get this straight. You're the management team that brought the company to the brink of bankruptcy. And now you're asking to get special compensation and consideration for continuing to run the show. And so I think that's the same mindset or questions that come into play is like, if you're trying to get a creditor to think differently about you, then you need to have a story about why you're going to be able to do better than what you've currently done. So they want to know, a creditor wants to know, who's the management team? Who are you bringing in? So maybe, Mike, to your point, one of the things that could change the conversation is like, we don't trust, your management because you have failed to do this, that, or the other. But if you bring in somebody who actually, and again, it all depends on what the resources are and what the lay of the land is and what the environment, the business environment looks like for that particular company. But if you were just to say, what, we're going to bring in somebody else, who is, an expert in this area to help us, come to a better place. And that person has a track record that might make a difference. They just need to know that you're shifting the conversation. And if you're not shifting the conversation, how is it that you're going to have a better outcome than what you've already got in hand?
I picked something up out of that response. I'm going to go back and highlight. You don't necessarily have to comment, but you're welcome to if you want to. And that is that at the end of the day, whether or not you emerge from the workout is heavily dependent upon whether or not you fix the conditions that led you to the workout in the first place, right? If you've got a lousy airplane and you get more runway, the airplane still isn't going to fly, right? It just has a longer runway to crash on, right?
Bingo.
And so at the end of the day, if you don't remediate the fundamental issue, right, then you're going to be right back where you started. And the thing about workouts too is the client, we hope, is at a structural disadvantage. What I mean by that is creditors are in workout conversations all the time as part of their job description, right? They'd rather not be there, but that's what they do for a living. A borrower, you hope, has never been in a workout scenario before. And so from an experiential standpoint, the client or the borrower is actually taking a knife to a gunfight, right? The people with whom they're negotiating have likely seen it all before 3 different times. But your client, for example, is fumbling around in the dark with a blindfold on for a flashlight that has no batteries left in it. Right. And I think that makes a big difference in terms of what you're able to secure from this. And then the creditors are making are making a decision too. If I allow this company to continue at the rate they're going, there's not going to be any liquidation value either. Right. So maybe we're better off kind of stopping the music and taking our chances and getting in line at this point, because if we wait, it just means there's going to be less available when we go to the buffet to sort of get our serving, right?
Right. Yeah, no, you nailed it.
So we're running out of time. We're only getting through a fraction of the questions I had, which is typical, but that's a good thing. But one I want to make sure we hit on before we get out is, what are the specific, no, that's not the question I want to ask. The question I want to ask is, at a time like this, do borrowers maybe have a little bit more leverage than in a time, say, 90 days ago, and we thought everybody was hunky-dory, roaring economy, et cetera, right? There's this saying that if you owe $1,000 and can't pay, you're in trouble. If you owe $1 million and can't pay, the bank's in trouble. Right? Is there a sense in your part that maybe there's more leverage on the part of a borrower because creditors maybe want to go the extra mile to just sort of keep things from going into delinquency? Is that a fair statement?
Yeah, we can talk about bankers and lenders. The bankers have what they call the special assets department, right? Which is basically foreclose on the assets, and then they're stuck with disposing or managing or administering those assets to make lemonade out of those lemons. And I think, Mike, to your point, how the current environment colors the conversation. Absolutely, right now, the fact that you as a business operator are in distress and you actually have problems should come as no surprise to the vast majority of creditors, bankers, lenders, and landlords that you're talking to. Then that comes back to the idea of, okay, so we understand maybe you got here because a lot of other reasons than even your own conduct. But how are you, going back to the storytelling, how are you going to articulate a vision of like, okay, so what do you need to do to get to a better place? And what do you want from me as the creditor? How can I help you? Or what would that look like? And then, it might be one of those things where right now, commercial landlords are looking at a lot of things that are, not as rosy as it was just a few months ago, right? In terms of their forecasting, in terms of rents to be collected and occupancy levels for, and I'm not looking at, real estate. There are many other aspects like this, but I think to your point, this is a new opportunity to have a conversation. So if you're not a repeat, workout candidate, and this is your first rodeo, or hopefully one of the first rodeos, you actually have a much better opportunity to dig yourself out of a hole if you can come up with a game plan that is viable and actually holds water. So, yeah, I think, we're all in a different place than we were just a few months ago. That gives you a lot more latitude with a lot less excuses than you would otherwise have to if this were just a flush economy and everybody's doing well, arguably, and you're not. Then how did you get here? I think that now is a different concept. What does well look like and how did you get here are two questions now that are more easily answered than they were just a few months ago. So I don't know if that maybe is the relevant point.
Yep. So, Tom, lots of other things we could ask, and then maybe some people may have other questions about, unfortunately, bankruptcy or something else that's related to this. How can they contact you if they want to maybe go right to the horse's mouth and get some questions answered?
Sure. So they could email me at Tom Rosseland. So it's Tom Rosseland, Rossland. And my email address is trosseland, TROSSELAND at BrawLaw. I'll spell that BRAWWLAW.com. Or they can call me at 404-351-1615, extension 107. And I am always available. So glad to help out any way I can. But for me, the differentiator is being invested in the outcome and actually helping a client see their way through this process. And it is a process, but I think there is more opportunity for a good outcome now, believe it or not, than it would have been just a few months ago, considering where we're all in this conversation together. So I think there's going to be stuff happening. There's things that can be done, and I am. My job is to be resourceful. So thank you for the opportunity, Mike. This is great. I hope I covered some of the areas you wanted to address.
Yeah, I think I know that we did. So that's going to wrap it up for today's program. I'd like to thank Tom Rosseland of Bodker Ramsey so much for joining us and sharing his expertise with us. We'll be exploring a new topic each week. So please tune in so that when you're faced with your next executive decision, you have clear vision when making it. If you enjoy these podcasts, please consider leaving a review with your favorite podcast aggregator. It helps people find us so that we can help them. Once again, this is Mike Blake. Our sponsor is Brady Ware & Company, and this has been the Decision Vision Podcast.